Calling our last case, Midwest Valve and Fitting Company versus City of Detroit. Good afternoon. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of your time if we don't use it all up. You may begin when you're ready.
All right. Good afternoon, Your Honors. My name is Greg Hanley, and I'm joined here today with my colleague, Ed Kickham, Jr. We represent the plaintiff. I'll reserve 3 minutes for rebuttal, if I may. Midwest Valve is a small family-owned plumbing supply company that's been operating in the city since 1961. Midwest filed this lawsuit because every year it got billed by the city for a fire safety inspection that it never received. After the suit was filed, the city filed not one but 2 answers admitting that the fees were for fire inspections. And as a matter of fact, it says that it imposes a fire inspection charge to pay for the direct and indirect costs of its fire inspection program. However, when plaintiff demonstrated that the city billed for 57,000 inspections that never occurred, the city changed its tune and began to refer to these charges as permit fees. And there was admittedly an extended skirmish in the circuit court over what these were going to be called and what their true nature was. But at the end of the day, we took the position that it doesn't matter. If you want to call them permit fees, you want to call them inspection fees, it's the nature of the fee that matters. And a classic example of a permissible permit fee is a reasonable building permit fee. Under those circumstances, the municipality provides an actual service, reviews the plans to make sure that they comply with, for example, the electric code, which has safety issues. And they also provide regulation in providing that service because it's ensuring that the structure that gets constructed is safe and appropriate and compliant with the codes. But these charges are much different, and they simply can't survive scrutiny as permit fees. Long before the Headley Amendment or Bolt, this court recognized that license and permit fees could be abused by municipalities because of the disparate bargaining power. You go to the government and you want the right to do something, the government says you have to pay for that right, and that right can be abused. And so the cases that evolved, beginning with...
And ultimately, that type of dispute is what led to the Headley Amendment passing with, quite a bit of support.
Right.
And so the question, let me just start, is there any dispute that the revenue collected through these charges go entirely to the administration and enforcement of fire prevention services?
There's no dispute that it funds the fire marshal division. And the fire marshal, Mr. Battle, testified that it covers a gamut of things, including training of arson investigators, the actual inspection activity, the commercial inspection activity, funds the actual office itself. So it basically covers the entire operational budget of the fire marshal division fire prevention program.
And so there's no remaining funds year over year that goes to the city's discretionary budget, which would clearly be a Headley violation, right?
Right. No.
And so, but your position is that while it's funding the fire prevention program, it's carrying more weight than it should for what you're getting.
Well, no. As to plaintiff and our proposed class who don't receive an inspection, there's no particularized benefit provided by the fire inspection program. The question is not whether they're using it for the fire inspection program. The point is that the fire inspection provides no particular benefits to the people who pay the fee and don't get an inspection, okay? So they're funding a general governmental obligation. Fire prevention is about as core a public function as you can have. Police and fire, going back to former colleague Justice Markman, who had the dissent in Bolt in the Court of Appeals that ultimately got adopted in large part by the majority in Bolt, where he was talking about you can't just call something a fire fee because it's financing a core public function. And that's what Headley is intended to enshrine and prevent.
So let me just think this through. Let's analogize it to an audit, right? There's some things that you just can't audit every piece of paper, so they randomly pick different areas and do paper audits to make a determination of whether there's anything that's not right here. Why wouldn't that analogy apply here? We've got a fire prevention program, we need to fund it, and they're gonna go through and they're gonna do inspections here and there, but not everywhere, but the entire program is paid by those who are going to benefit because you're aware, hey, I could be subject to this audit, and therefore I'm going to remain in compliance.
Well, in the audit analogy, if you audited every single person who was subject to the fee, but you didn't check everything, I would agree that an audit is not designed to uncover everything. You test things and then you decide whether the financial statements fairly present the condition of the company. But if you're charging somebody an audit fee and you don't audit them at all, that's the situation that we have here. If they inspect a property a mile down the road, that confers no benefit on Midwest Valve, who doesn't receive an inspection. And what the cases say is fire inspection activity is not a service to any particular property owner. It's a service to the public in general by reducing the risk of fire generally. So there isn't any set of circumstances under which, and the city admitted, and this I think is really important, we asked them what are the benefits of fire inspections? And the city said, performing fire inspections primarily benefits the owners of the properties inspected, but has a secondary and collateral benefit to the public as well. So there's two beneficiaries. There's the property that actually gets inspected, and there's the general public. So if you pay this fee and you don't get the benefit of an inspection, you are in the exact same position as the general public who aren't forced to pay the fee.
But if you pay the permit fee and you don't get the inspection, but there are other properties that have, and they fund this fire marshal program, and we're talking here about commercial properties, right, multifamily residential, like properties that are not a single family home, right, and that present different fire prevention, firefighting risks, things like that, right? So even if you didn't get the inspection, the fact that the department exists and has fees to support making sure like that these risks are prevented and addressed for all the properties that are serviced by the fire marshal, even if you didn't get the inspection yourself, you're still benefiting from that. That is still a benefit to you as the payer of the permit fee.
But I'm benefiting, the important thing is I'm benefiting in no way different than the public benefits. That is the whole point of Bolt. If the public benefits are subsumed into that particular benefit, then it's a tax. The Michigan Association of Home Builders case, which 5 of the current members of the court were part of that unanimous opinion, involved a building permit fee. And they were actually doing the building permit work. So there's, unlike this case, everybody who paid that fee got some benefit for it. But the problem they had in Troy was they were collecting too much, and they had these surpluses. And the court found that violated the relevant statute, which required a reasonable relationship between the amount of the charge and the benefit conferred. And that basically ties you back into Bolt, the proportionality standard. So in that case, everybody got a benefit, and it was still a tax. a direct benefit, and it was still a tax because it was too much. So you got to go back to the early cases that Bolt relied upon. The Werner case.
But that kind of took me to my first question. They're collecting this fee, and is there any evidence it's being used for the general fund, which was, I think, what happened in the case you're referring to?
Well, no. Our whole point is the operations of the Fire Marshal Division is a general fund responsibility. If you're asking whether they're using it for police patrol.
Libraries or anything else, they're not. They're using it strictly for fire prevention. That's what brings you here. That's why you're in the Supreme Court.
Yes.
Right? It's not that clear.
Yes, there's no question that they're using it to fund what they call the fire prevention program.
People who pay the permit but don't get inspected, they still have the benefit, if you want to call it a benefit, but they still have the ability to call up this division and get guidance as to what's required under the permit and what they're required to do, so that in the event their number comes up in the audit and they actually get inspected, that they are in compliance and not subject to any further fees or fines, correct?
Well, there's nothing, that may happen, but there's nothing in the record about that. There's nothing in the record about that being a service that's provided.
It's not established that the people subject to the permit fee can and do get guidance from the, this division of the fire?
They might, but the members of the public and single-family residentials can call and get guidance. As a matter of fact, Mr. Battle testified that they handle complaints.
They're not going to get guidance on a permit that they don't need.
Fire prevention is an activity that benefits the entire public. It's not a particularized benefit to the landowners. Even the landowners that get inspected. We cited the Missouri case, the building owner's case from Missouri, which is under the Hancock Amendment, which is almost identical to Headley. Mm-hmm. And they said it's a tax because it's not a service to any landowner. It's a activity for the benefit of the general public. Just like police couldn't charge a police fee because you're in a higher crime area and say you're getting a special benefit from this because you're in a higher crime area. The activity
No, but you
itself.
could if the police were doing a traffic control at your property, right? If you paid a permit fee to have the police come and do traffic control.
There may be a set
Or
of
in
police.
general for commercial businesses over
Right.
whatever, that this is a service that the police does. It does. I mean, why are we looking at it only when you're looking at the proportionality factor? Why are we only looking at it with, you know, the quantifiable benefit received by the payers as opposed to the reasonable proportionality to the regulatory purpose when we're talking about a permit fee? If the amount charged is proportional to the amount it takes to provide that regulatory service, isn't that the proportionality analysis as opposed to, well, it's not, to each individual person isn't getting the same benefit and therefore it's not proportional.
And it's not proportional. And remember, the Court of Appeals didn't find that the benefit, or other than an incidental benefit, was the fire inspection program. They said the benefit is you get the right to operate your business, okay? That's the benefit, because if you're not inspected, even the Court of Appeals wouldn't have said there's a specific benefit for that. They said, over and over in their opinion, the benefit was getting the right to operate your business. Okay, so how do we value that benefit, right? They have a set of charges that are nonsensically based upon how big your facility is and the relative fire risks, okay? So a building might pay $109, another building might pay $299. There's a whole fee schedule. But the rationale of the fee schedule is how much time is it going to take to inspect this property, okay? But there's a disconnect. The fees are based upon that particular benefit, which doesn't happen. And they're valuing the value of being able to operate your business by conditioning it on how much property you occupy and how much fire risk you prevent. And that has nothing to, there's a total disconnect between that and the value of the benefit that the Court of Appeals relied upon.
Counsel, didn't the trial court actually list out several other benefits individualized benefits that you received, your client received?
No, they listed other benefits, But those, are, like the benefits we've been talking about, are benefits that extend to the public, meaning arson investigations. Okay, they're training arson inspectors. They're doing plan reviews of other people's properties to ensure compliance, plan reviews, and training arson inspectors, and all of that stuff. How is that a particularized benefit to Midwest Valve as opposed to the rest of the
It's
public?
an interesting question, because I would venture that most government services, even when they have an individualized benefit, also benefit the public. It's sort of the nature of government.
Right, but what,
You're 45 seconds, if you want any opportunity to rebut,
yes, I'll stand down.
because
All right.
I suspect we're gonna have questions for you in rebuttal. I apologize
No,
to my colleagues. We generally like it when they run out of the rebuttal time, but I wanted to save something for you, because I suspect we're gonna have questions for you in rebuttal.
You just used up the rest of his time.
No, they stopped the clock. I
Clock's
saw
still
that.
going. No.
I saw that. I appreciate that. Thank you very much, Jeff.
Good morning. May it please the court, Eric Gabo appearing on behalf of the appellee, the city of Detroit. I realize my time is short, so I'm going to focus on three main issues. The first is that plaintiff claims that the fee at issue finances what it characterizes as a core fire protection service, and that under Judge Markman's dissent in the Bolt Court of Appeals decision, these types of core services should be paid for by taxes, not by fees. My first observation with regard to that argument is this court did not adopt that specific reasoning when it issued its decision in the Bolt case. But more importantly, this case does not involve core fire protection services. So what are these services? I think you can ask anyone on the street and they'll tell you what they are. Core fire services are firefighters, they're fire trucks, fire stations, fire hydrants. They're responding to accidents, disasters, emergencies, EMS services. These are the core fire protection services that are provided by every community, everywhere, and they're provided to all citizens in those communities. These are funded by taxes, and they're funded by taxes in the city as well, because none of these functions, none of them, are paid for with the fees at issue in this case. I think it might be helpful to examine what the fee actually does pay for in the context of the fire department's overall budget. For example, one of the exhibits plaintiff relied on showed that for fiscal year 2017, the total budget for the fire department was $132 million. The city's expert also produced evidence that the direct costs of the fire prevention unit for that year were about $3.1 million. In other words, that's about 2.5% of the total budget. That other 97.5% of the fire department's budget is devoted to core fire services, putting out fires, that type of thing. It is not devoted to this specialized program that was enacted just to assist this specific subset of companies. I think it's also helpful to consider what would happen if plaintiff did not pay the fee. If plaintiff didn't pay this fee and had a fire, what would happen? The fire department would send out its firefighters from its fire stations in its fire trucks and put the fire out using fire equipment, all paid for by taxes.
Explain what your point is there.
I'm saying that the concern that was raised about allowing communities to charge fees for core services is that basic things that you expect, basic protections the government is required to provide, could be denied if you don't pay money. But that's not the case here, because if you don't pay, we're still coming out, because all of these typical core protective services are paid for by taxes.
So if plaintiff doesn't pay, what are they not receiving?
What are they not receiving? Well, they're not going to receive the occupancy permit. They won't be able to use their property for that particular purpose, which is similar, again, to a license fee.
But they won't get inspected either. I mean, if they don't pay the fee, is that one way of getting their inspection, which ironically they say we're not getting the inspection we're paying for?
I don't know whether
I've
they
never heard a
would get
business
the,
complain about that, by the way. Usually they'll be happy to pay the fee and hope the inspector doesn't come by. But in this instance of a Headley claim, is that one way they can get their inspection? If they don't pay the fee, is the inspector going to come out?
I don't know how the city does that. I know that they try to schedule them with a certain priority, but I don't know whether calling and demanding it would do it. But and a good point that I'd like to...
Let me ask another question. If they called and said, I'm paying my permit fee, I want my occupancy, I want to do everything properly, but I want to make sure that my place is in tip-top shape, please send out your inspector. Will they get an inspector?
I think that they would, Your Honor.
Okay, I'll tell you what troubles me with the Court of Appeals opinion. It appears to reason that the imposition of this fee is not a tax because it's paid in exchange for a permit to do business. And that can't possibly be the way around Headley. Right? Is it just, if you get a permit to do business in our state, it's not a tax? Is that the rule of Headley?
No, first of all, they're
Is that
not paying this...
Thank you for giving me yes, or agreeing with me. It's not the rule of Headley. But isn't that what the Court of Appeals said? I'm troubled by this Court of Appeals opinion.
No, I don't think that's what the Court of Appeals said. The Court of Appeals said that this is one of the benefits that they receive. The Court of Appeals went through the entire
The benefit
analysis.
they receive is you pay the fee, you can do business in our city.
That's not correct. You have authority to use your property for a specific purpose, but there may be other requirements you need to follow as well before you can actually do business. Some of these entities have to get a license. This is not one of them. In fact, the vast majority of these entities out there don't have to get a license and don't pay a license fee.
I don't know that that provides me any more comfort. There's always, but you paid this fee, now there's more fees you have to pay, and now you can do business in our city. Right? I mean, the whole idea here of Headley is democratic accountability for revenue collection from the general public, and this whole distinction between a tax and a fee, there has to be something tightly related to the fee, and I think it has to be something much more than simply, here's your permit, you're now entitled to do business in our city.
Well, that's not the way the Court of Appeals analyzed it. It's not accurate. What they are paying for with that fee is to fund not inspections. They're paying for the entire regulatory program, which is the same as a typical license fee. When you pay a license fee, you're not paying for an inspection. And in fact, the city may go out and inspect sometimes. It may not go out and inspect sometimes. But what you're paying for is for an entire body that regulates that industry, that then can go out and gather information, can answer questions about the operations. So, and I think a good, interesting point, though, is this is not a case about no inspections. This is a case about the frequency of inspections, because every single one of these businesses has an inspection. You have to have an inspection to get in the city's database. And in that initial inspection, the city gathers information. It has information regarding the type of facility, what it's constructed of, what materials are on site, ingress and egress, where the nearest fire hydrants are located, the fire suppression systems, all of these things. So every entity that is covered by the city's program has had at least that one inspection. And all that data goes into the city's database that the city can then rely upon, that companies like Midwest Valve can call and ask questions about. If there's a fire, the people responding to that, who are not covered by this fee, can then find out more about that facility before they even go in there. So all of these things benefit the companies that pay the fee. Another point that I'd like to raise is that this was made by the amicus party. Plaintiff seems to suggest that this is some unusual money grab by the city to get money improperly that should have been done through taxes. But that's not the case. Communities all over Michigan, and in fact all over the country, do this exact same thing. And they do it typically through national codes that specifically say you can require a permit for this type of issue. and you can charge a fee for that. So plaintiffs now are saying, well, no, it has to be a tax. Well, the result of the plaintiff's argument is that if in fact this is unlawful, every one of those fees in every one of those communities now becomes jeopardized. And this would throw everything into complete chaos. So it's not something strange that the city came up with on its own. This is followed around the country and around through Michigan. And I think that's another important point between the cases that plaintiff cites that he says show that this type of program can't be financed through fees. Those cases, which again are out of state, not binding on Michigan, but typically what has happened is the defendants in those cases have admitted they funded these things through taxes, and taxes were declining, and they did this to raise more money. That's what they have admitted in these cases.
So what's the clear line that we are going to be looking for? So you say that this is done all over the state, all over the country. So when does it cross the line? Does it require a defendant to admit that that's what they're charging the fees for?
Well, I think the court needs to look at the standards that are set, and the standards that were set in Bolt and the subsequent cases. Every one of those standards has been met here by the city. This is clearly a regulatory purpose. There's no question. When you get to the proportionality, plaintiff has in fact stipulated that our costs are greater than revenues taken in. They make this argument about core services not being covered by fees, but again, these are not core services. This is a very narrow program. It doesn't benefit homeowners. It doesn't benefit people who own vacant property. It doesn't benefit someone who has a parking lot. So a large segment of the whole population of the city does not benefit from this. And this is completely different from the types of fees that were struck down in the other cases, such as Bolt, such as Jackson County. Those benefited everyone in the city. This does not benefit everyone in the city. It benefits these people, one, who now are able to use their properties for a very specific purpose and possibly a hazardous purpose, and two, they receive the benefit of the entire program.
But shouldn't the focus not be on whether the government's going to permit you to use your property in a certain way or not use your property in a certain way, but instead on what the government is providing you as a direct benefit for the payment of this?
I think it's both, Your Honor. I mean, the same thing is true with again, I keep coming back to a license fee. That's an undeniable benefit to the person who pays that, allows them to operate their business. But the Court of Appeals, again, did not focus entirely on that. The Court of Appeals also noted that this fee pays for all of those people at the fire marshal fire prevention unit. And they have programs, they keep this data, they have training, they answer inquiries about these specific technical questions. These are all things that benefit the people paying that fee, whether or not they receive an inspection or not. And again, plaintiff keeps coming back and characterizing this as, well, the inspection program, it is not an inspection program, and they've stipulated to that. So I don't think the court should be confused by that. A couple other points that they make. One of the things they come back to is they say that this pays for arson investigators. First of all, that was not raised at the trial at all. And the testimony of the fire marshal, actually, he testified that arson is not even part of the fire marshal. He said that at one point it was, but actually that was a completely different unit. It was not part of the fire prevention unit. So that's a red herring there. Plaintiff also says that the city's fire prevention employees review construction plans, and therefore that benefits the public. They do review construction plans, but they do not review construction plans that have to do with single-family houses. The plans that they do review are the same, from the same properties that are covered by this, this fee. The final point that I'd like to raise is that there is no reason for this court to grant leave in this case, because contrary to plaintiff's claims, the Court of Appeals decision does not eviscerate the Headley Amendment. The trial court and the Court of Appeals simply applied the principles that were announced in Bolt and Westlake and Morelli versus St. Clair Shores in a straightforward way in accordance with the law. Plaintiff claims that this destroys the Headley Amendment because this allows the city to charge a fee in any amount for any purpose. But that isn't what the Court of Appeals said, and we wouldn't agree with that anyway. We agree that we can't have an unlimited fee. It has to be proportionate to the costs, but we met that standard. And also, it can't be for any purpose. It has to be a proper regulatory purpose. And if you go back to Morelli, you go back to Werner, you go back to all of these cases, there's simply no question that this type of program, this type of function, is a regulatory function. So there's nothing new that's raised by the Court of Appeals decision, and there's no reason why this court needs to grant leave in the case.
Thank you.
Justice Clement, you asked for some ideas on a clear rule. Well, here's the clear rule. It comes from Werner, which is a 1914 case that Bolt relied upon extensively. It had to deal with these auto license fees that they were using to build roads. And they were struck down by this court. And the clear rule is that the revenue derived from the fees cannot be disproportionate to the cost of issuing the license, which is a nominal cost, and the regulation of the business to which it applies. Here, this right to do business is just a naked right that's not tethered to anything they've done to ensure that you should be able to do business. In other words, if you receive an inspection, they can justifiably say, well, you can't do business unless you clear this inspection, right? But if they're doing nothing with respect to your property and charging you the fee, there's no proportionality there, and it does open the door for when it's not tethered to a service provided to the particular payer. It leaves the door open to all of the things that Justice Markman said would be a problem.
So compare that to a license, where you get the license to be able to sell a product or to practice your profession.
Right, and the license fee has to be proportionate to the Secretary of State has costs, okay? And you got to go there and you got to get your picture taken. And
So at some point in this situation, the city says, we may, if there's concerns, we may, ramp up our inspection process. Because
Sure.
we know that in certain areas, there's issues. So then they're going to be coming into those businesses in certain areas.
They could change their conduct and they could change their method of charging, but we're looking at how they've done it since 2013. And in a 5-year period, there are 57,000 properties that paid this inspection fee to the tune of $3-4 million a year and got no benefit, no direct benefit from this program that wasn't also shared by everybody else in the community. And for that reason, it has to be found to be a tax, particularly because the way it is determined, the amount of the fee is determined nonsensically by how much fire risk you have and how big your property is, but now we're measuring that benefit as the value of being able to operate your business. And what's the value to General Motors of being able to operate their business by paying for a fire inspection fee for the Rensen versus Midwest Valve, which has a 2,000 square foot facility, ever. The value of doing business, I don't even know how you quantify that in any kind of Headley analysis, but it was clearly the basis of the Court of Appeals ruling, because if you impose the requirement of a particularized benefit, which is what the cases say in Legion, that what they're doing here is not a particularized benefit, and for that reason it's a tax.
Counsel, do you think Westlake was wrong
Do I think Westlake?
Yes, was it wrong? Because I know
Not-
you tried to
no.
distinguish it, as you said, that case, they went into more benefits.
They listed like 12 different benefits other than being able to use the facilities. And again, if the forecast about all permit fees are now going to be up in the air if the court rules in our favor, I think the reality is it's only the abusive permit fees. There's no question that license and permit fees are not taxes if they satisfy the 100-year-old standard of Werner, which is that you're recovering the cost of issuing the license and you're recovering the cost of directly regulating the payor, right? And that's not happening here. And that was not the case in Westlake, where they had all sorts of other benefits that they did say you got a right to operate, but then they talked about all the other benefits as well. So, and none of the benefits of this program are unique to the people who have to pay this fee.
Aren't you glad I saved you 38 seconds?
What's that?
Aren't you happy I saved you 38 seconds?
Yes, I
for
appreciate
rebuttal?
it. Thank you.
Thank you both.
Thank you both. The case will be submitted and the court is adjourned until December.